context of what has recently happened with the Treasury and the Department of Justice and the setting up of the $1.8 billion cop beaters slush fund, the very week after Police Week here in Washington, I thought that Mr. Schwartz's comments about the merit of standing indicated quite clearly why that self-dealing cop beaters slush fund is so deeply, deeply problematic, without even going to the Trump family tax amnesty that it provided with literally one lawyer's signature on the document. Usually, if there's a contested matter, there are two parties. In this case, one lawyer signed it. And we don't know whether he signed it as acting attorney general or as Trump's personal lawyer, but we do know that it created a $1 billion cop beaters slush fund, and we do know that it gave the Trump family and associated businesses amnesty from any tax mischief or fraud that they may have committed. And it's really hard to see how there was any real case or controversy in that little scheme. But I also want to note that Mr. Schwartz is here without blue slips from the senators from the Second Circuit state. And just to remind everybody, I warned when we got rid of the circuit court blue slip that this was going to be unpleasant, and I've had colleagues on the other side express their dissatisfaction when they were ignored for blue slips. So here we are again. I don't want to hear a lot of complaining about blue slips in the future after we go through these exercises and ignore senators' rights to have a blue slip. But I want to talk about something different that just happened fairly recently. In Wyoming, a U.S. attorney was sanctioned by the federal court. 9 criminal indictments were thrown out as a result of improper conversations with grand jurors by the U.S. attorney. He called the defendants murderers, even though there were not homicide charges in the proposed indictment. He called them bad guys, not run-of-the-mill criminals. He handed out his business cards to the grand jurors and invited them to get in touch with him privately. A 1L could do issue spotting in that fact pattern and see massive, massive error and misconduct. It was challenged by the lawyers for the defendants who said this is not an isolated lapse. It has metastasized into systemic institutional failure, and the taint is widespread and continuous. And guess what? The court agreed. The court said that the cumulative effect of many known instances of misconduct, implying that there may be further unknown instances of misconduct, justified dismissing the complaints. The court found that none of the U.S. attorney's excuses carry water when viewed, I'm quoting here, when viewed against the volume and the flagrancy of the misconduct, end quote. And then concluded that this U.S. attorney had abused his special position of trust. Here's what's interesting about that order and that U.S. attorney. That order was filed on May 15th of this year. 3 days later, on May 18th, that U.S. attorney, who'd been voted on in this committee, was slipped into the big en bloc list for confirmation without anyone in the Senate being told about that May 15th order regarding his professional misconduct. And I gotta say, I don't think that's the way this committee should operate. I think if there's an order from the federal court challenging the integrity and the competence of a United States attorney who is pending before the United States Senate, and we're not informed about that order for 3 days, and we don't even get an individual vote on that nominee. Instead, he's buried into the en bloc group, which I think was 49 different confirmations that day. That's not what the Senate is supposed to be. This guy should not be a U.S. attorney, and his confirmation should certainly not have been slipped in without disclosure of this order into an en bloc confirmation vote. I think the Senate was misled by that.
This was not a routine Senate floor complaint about paperwork or procedure. Senator Sheldon Whitehouse framed it as something much more serious. an accusation that the Senate confirmation process had been used to quietly advance a federal prosecutor despite a recent court order describing significant professional misconduct. And Whitehouse made clear from the beginning that, in his view, this was part of a larger institutional pattern. He opened by criticizing what he described as a cop beaters slush fund, allegedly connected to January 6 related settlements and tax protections benefiting the Trump family and associated businesses. His remarks suggested concern not only about the legality of certain decisions, but about whether politically connected individuals were receiving extraordinary institutional protection. It is important to note that these were political allegations raised during a committee hearing, not judicial conclusions established within the remarks themselves. But Whitehouse's language was designed to frame the issue in moral and institutional terms, not merely procedural ones. He focused especially on what he characterized as the unusual structure of the legal agreement. A document reportedly signed by only one attorney, uncertainty about whether that attorney acted in an official or personal capacity, and the creation of what he repeatedly described as a billion-dollar settlement mechanism benefiting January 6 defendants. From there, Whitehouse pivoted into a procedural issue that may sound obscure to casual viewers but carries enormous significance inside the Senate: blue slips. The blue slip tradition allows senators from a nominee's home state to signal approval or opposition to judicial appointments. While the practice has evolved over time and is not always binding, it has historically functioned as an important courtesy and oversight mechanism. Whitehouse reminded the committee that he had previously warned eliminating or weakening blue slip traditions for certain judicial nominations would eventually create institutional backlash. His argument was essentially this: once the Senate weakens procedural protections for one side, those same weakened standards eventually apply to everyone. That alone would have made for a notable institutional critique. But then the hearing moved into something much more explosive. Whitehouse described a federal court ruling involving Wyoming U.S. Attorney Darin Smith, who, according to the senator's remarks, was sanctioned after 9 criminal indictments were dismissed because of improper conduct involving grand jurors. The allegations Whitehouse outlined were striking. Referring to defendants as murderers despite no homicide charges, calling them bad guys, distributing personal business cards to grand jurors, and inviting private communication outside normal judicial procedures. Those details matter because grand jury proceedings are governed by extremely strict ethical expectations. Prosecutors hold extraordinary influence in those settings, and courts are highly sensitive to conduct that could prejudice jurors or undermine the fairness of the indictment process. Whitehouse emphasized that defense attorneys argued the conduct reflected systemic institutional problems rather than isolated mistakes, and according to his remarks, the federal court substantially agreed. He quoted language from the ruling describing the volume and flagrancy of the misconduct and stating that the prosecutor had abused a special position of trust. That alone would raise serious questions about professional fitness. But Whitehouse's central accusation involved timing. According to his remarks, the court order was filed on May 15. 3 days later, Darin Smith was reportedly included in a large en bloc Senate confirmation package without senators being informed about the disciplinary ruling beforehand. That procedural detail became the heart of the controversy. Whitehouse argued that senators were effectively denied the ability to properly evaluate the nominee because the court's findings were not disclosed before the confirmation vote proceeded. In his view, the nominee was effectively buried inside a mass confirmation package involving dozens of appointments, reducing the likelihood of focused scrutiny. This is where the hearing became larger than one prosecutor or one court ruling. The Senate's constitutional role in confirmations depends on informed consent. Senators cannot meaningfully evaluate nominees if major disciplinary findings emerge without timely disclosure. And that concern reaches beyond party politics. Historically, confirmation systems rely heavily on assumptions of procedural good faith. Relevant information will be surfaced, serious ethical concerns will be disclosed, and controversial nominees will receive heightened scrutiny. Whitehouse's argument was that those assumptions may no longer hold. Perhaps the most important phrase in the entire speech came near the end. I think the Senate was misled by that. That wording matters because it moves the accusation beyond bureaucratic oversight into institutional trust itself. And that is what made these remarks politically significant. The larger issue was not simply whether one prosecutor behaved improperly. It was whether the Senate confirmation process can still function transparently in an era of increasingly aggressive procedural maneuvering and hyperpartisan institutional conflict. Because once lawmakers begin believing that important information can be strategically delayed, minimized, or buried inside procedural mechanisms, confidence in the integrity of the confirmation system itself begins to weaken. And once trust in those systems erodes, every future confirmation becomes harder to separate from accusations of political manipulation. That is the broader warning underneath Whitehouse's remarks. Not just that misconduct occurred, but that institutions may no longer be reliably exposing misconduct before power is formally granted. What do you think? Should federal nominees facing serious judicial criticism or misconduct findings automatically receive separate confirmation votes and mandatory disclosure reviews, or are streamlined confirmation procedures necessary for the Senate to function efficiently? Leave your thoughts in the comments below. And if you value long-form congressional analysis that goes beyond headlines and examines how power, procedure, and institutional accountability really operate inside Washington, subscribe to Capitol Oversight for more deep oversight coverage and hearing breakdowns.